Yes, I think that will be good to have your voice at the beginning of the video.
Okay.
So when you're ready, just make sure to have a short answer for the question. Okay, I'll mute my audio.
Okay. One of the questions that I'm often asked is, are DIY wills legal? The short answer to that question is yes. Any person could choose to write their own will. However, it's certainly something that's not recommended because even though you don't have any legal knowledge, your document would still have to follow the same formalities. You would have to ensure that you include all of the key people in your document. Who I refer to as the key people are an executor or personal representative to administer your estate, and also the people you want to actually receive your items. Lastly, the document has to be properly executed, meaning when you sign the document, it has to have the right amount of witnesses and be notarized. So, can you do your will yourself? Is it legal? Absolutely. Should you? Probably not.
That was great. That was great. Thank you so much. Great. So, did you see a question that you said, "Oh, I can do this right now"? Any preference?
I would have to look at the list again.
Don't worry. Let me just share my screen again. Okay.
All
I think
right.
that's it. Okay.
So, how long does a will last? We can certainly do that one.
Okay. Let me just stop that. And when you're ready, I'll mute myself again.
One question that I'm often asked when clients come in to create their new estate plan is exactly how long does a will last, or how soon will I have to do this again? The short answer to that question is a will could potentially last forever. However, the only way for it to really last forever is if you really have no changes, no life changing changes. That means your family dynamics are pretty much the same. The people you want to leave items to are pretty much the same. There's been no new births or deaths. The individual that you listed as your personal representative or executor is still living and still competent to do it. So your will could potentially last forever. But if you have any significant changes, if you've moved, had a death, birth, or anything really that could affect the distribution of your estate after your death, it is always recommended that you update it.
Amazing. Thank you so much. Okay. Let me just share my screen again so we can pick another question.
Okay, so does a new will cancel an old will?
Okay. Great. When you're ready.
One of the other questions that come up often are individuals who come in to our office because their parent or loved one had a will from a very long time ago, and they feel as though those provisions were either more favorable to them or made more sense. And then they create a new one, and they're wondering, well, does that new one override the old one? Even if the provisions or the way they distributed their asset in the old one and the new one are different, can they be combined? The short answer to that question is a new will is going to revoke a prior will. There are circumstances where the new will might not have been properly executed, or there may be some other issues with it that will allow an old will to be used. But typically, an individual has the right to update and revoke their will as often as they want to. So if a new will is drafted, it does override any old one.
Great. Thank you so much. Okay. I'll go back to share my screen.
All right. Let's see. Can I leave my house to someone in a will? Let's do that one.
Great. Okay, I'll mute myself again. And when you're ready.
As we're drafting estate plans for individuals, one of the questions that often come up is, can I actually leave my house to someone in my will? The short answer to that question is yes. However, it's important to understand that a deed, the way a deed is written, is ultimately going to override what you put in your will. What I mean by that is, if you own a house by yourself, there are no other owners, certainly leaving it in your will is appropriate. But if you have a piece of property that's owned jointly, for example, with rights of survivorship, that means two people own the property together. And when one of them pass away, the person who survives inherits their share. So in that type of situation, even if you were to indicate that you want someone else to have it in your will, the provisions of the deed, the way the deed is written, would actually override what you've indicated in your will. So yes, it can be left through a will, but it can be overridden if the property is not owned by one person.
Amazing. Thank you so much. Okay. Do it again. That's it.
All right. Let's see here. Do you need to list all assets in a will? Let's go there.
Great. I'll stop sharing. And when you're ready.
Another question that comes up quite often is whether or not a person should list all of their assets in a will. And really, the answer to that question is it depends. So, if we're leaving the majority of our assets to one person or a group of people, then it's perfectly okay to leave pretty generic terms stating that you want all of your assets, both real and personal, to go to specific individuals or a specific person. But in some cases, if you have heirlooms, if you have specific items that are important that you want to make sure goes to an individual and no one else, then you can certainly write that in your will. Because this is a public document, however, you may not want to to have a laundry list of items that you want to leave to individuals. You may instead opt to have a separate memorandum where you detail these specific items and you just reference it in your will. So while it's possible, it's not necessary, and at times it can make it a little bit confusing.
Great. Thank you so much. I'll share my screen again. Okay.
All right. So is the oldest child next of kin? Let's go to that one.
Great. I'll stop. And when you're ready.
Something that comes up far more often than it should, specifically in communities that look like mine, are situations where the oldest child believes that they are in fact the next of kin, or they are the person who should be in charge because they're the oldest. But the reality is, in cases where there's not a spouse and we only have children involved, the children are the only heirs of an estate, for example, all of those children have equal rights. and will, unless there's a will to the contrary, will inherit in equal shares. And when I say they have equal rights, that means they have equal right to serve as personal representative or executor of the estate, equal right to make inquiries. So there is no hierarchy there. And being the oldest child does not grant anything special. You just happen to be the oldest, but no special authority comes with that.
Great, thank you so much. I didn't know that was actually a frequent question, you know? Like sometimes I
Yeah,
read them, but I
people
cannot
do seem
picture the
to think that
situations.
if they're the oldest, then they should be in charge.
Yeah,
Um, okay, so I feel like how to avoid probate is
okay.
something I might be able to answer relatively quickly.
Okay, great. Yeah, answer shorter than a minute. That's what we're looking for now. Okay, thank you so much. When you're ready.
Many clients come into my office, and one of the questions that they ask is, how do we avoid probate? And I think the reason why I get asked this question is because probate is painted as this big, ugly, scary place. And in some states, it can be very complicated. In North and South Carolina, however, probate is not so bad. However, if a person wants to avoid probate, there are a number of ways that they could do that. One of the ways is to create a trust. Items that are transferred in trust prior to a person's death, or if they have what's called a pour over will, directing that their assets pour into a trust after their passing, those items will not go through probate. Likewise, there are different ways of setting up bank accounts, such as making them payable on death or making sure that beneficiary designations on life insurance policies and the like are up to date. If all of those things are done, probate is something that can be avoided. However, if there is no estate plan, there is no trust, there is no accounts made payable on death, and we have real property, then probate is likely going to be inevitable. But the way to avoid it is to create a solid plan, perhaps consider a trust if it's appropriate for your specific set of circumstances, make sure beneficiary designations are up to date, make accounts payable on death, and in the case of real property, having a joint tenancy, meaning owning it jointly with another person so that it goes to them after your death. Those are all ways that probate can be avoided.
Amazing. Thank you so much. Okay.
All right, let's see. Um, Scroll down a little bit. Let me see what else we have.
Yeah.
Scroll down a little bit more.
Sure. Oh, sorry.
Oh, you're fine. Scroll up a little bit more.
Yeah.
Okay, let's do what is the difference between elder law and estate planning?
Okay, great. I'll stop sharing and when you're ready.
It actually surprises me the number of people who do not know or have never heard of elder law. What is the difference between elder law and estate planning? Naturally, is a question that's asked very often. The two are actually very similar. There's a great deal of overlap between the two, in that in both scenarios, you are planning for the inevitable and planning for the future. However, when we're talking about elder law estate planning specifically, we're focusing more on an individual's needs for long-term care. We're focusing more on individuals who may need to qualify for Medicaid in the future. We're focusing more on asset protection. In some cases, we're focusing on providing for an individual who has special needs. So, whereas in traditional estate planning, we're just looking at appointing agents and divvying out assets, when we factor in elder law with estate planning, we are creating a plan that's going to make it easier for these individuals to have assistance in the future when they get to a point when they can no longer care for themselves. So that's really the big difference, but both involve similar type of planning.
Amazing. Thank you so much.
I think right above that question,
Let me just.
I saw something else. Who makes decisions if you are incapacitated?
Okay. Great.
A question that's not actually asked frequently enough, at least not early enough in the process for it to matter, is who will actually make decisions when you are incapacitated? So, in that scenario, if you have a power of attorney, a power of attorney is an agent whom you've appointed using a power of attorney document. That person could typically make decisions for you if you are incapacitated. If you are incapacitated and you're not able to direct other people to do things on your behalf, your family member may need to go to court and petition a court to be appointed as your guardian. So, in that case, a guardian can make decisions for a person who's incapacitated. But there's not really a default person. The person who makes a decision for you when you are incapacitated is a person you choose or the person who a court appoints. So it is very, very important, even more so, in my opinion, than creating a will or a trust, to have a good, durable, and medical power of attorney so that there is an agent already in place to make decisions for you if you are incapacitated. Otherwise, a court will have to be involved so that a guardian could be appointed so someone could step in to take care of your affairs.
Wow. Thank you so much. Okay. That's great. Okay.
All right. Let's see here. How can I see someone's will?
Okay. Stop. And when you're ready.
One of the questions that we are often asked by heirs is, how in the world do I know that my loved one has done what they're supposed to do? How do I get a peek at their will to see how they've structured it or if everything is okay? The short answer to that question is there's nothing that you can do while the individual is living to force them rather to show you their will. The document is not recorded somewhere prior to their death, so it's not something that you would see. After a person is deceased, however, any will that they had would be filed with the probate court. At that point, it becomes a public record. And at that point, you could reach out to the probate court in the county where they lived or where their estate is being probated and get a copy of their file, including their will. Prior to death, however, you just got to sweet talk them.
Okay. Thank you so much. Okay. Share my screen again.
Let's see. What are the 4 must-have documents for estate planning?
Great. I'll stop sharing, and when you're ready.
All right. One question that I'm always asked is, what documents do I actually have to have as part of my estate plan? And there are actually 4, potentially 5 documents that are very important for you to have in your estate plan. The first is a durable power of attorney. A durable power of attorney appoints an agent to manage your affairs, your financial affairs, to be able to pay your bills and get in contact with your creditors and do things on your behalf if you are incapacitated or if you direct them to do it prior to. The next document is a medical power of attorney. It could be the same person you've appointed to manage your finances, but in some cases, people realize that there are certain family members that are better at one thing than the other. So a medical power of attorney would appoint an agent to make medical decisions on your behalf. The third is a will and or a trust. So both will and trust will distribute your assets. A trust can be utilized during your lifetime. A will is only effective after your death. But both of these documents would not only appoint someone to manage your affairs, but also direct how you would want your estate to be distributed after your death. And last but certainly not least is a living will. A living will is not the same as your last will and testament, but rather a document that comes into play if you need life sustaining treatment. So, for example, if you are incapacitated and doctors have determined that you are at a point of no return, this is the document that would tell your agent and tell medical professionals whether or not you would want life support, whether or not you would want to be force fed, whether or not you would want life sustaining treatment, or if you would prefer to have a natural death. So your 4 documents are a last will and testament and or a trust if appropriate, a durable power of attorney to allow someone to manage your finances, a medical power of attorney to allow them to make medical decisions for you, and a living will to direct individuals on what type of life sustaining treatment you would want.
Perfect. Thank you so much. Okay. That's it.
All right, let's see. What happens if someone has dementia and no power of attorney?
Great. I'll stop, and when you feel ready.
As an elder law attorney, a question that we are asked often is, what happens when someone has dementia and has no power of attorney? The answer to that question is, it depends. On what exactly? It depends on really what level of capacity this person has. So, having a diagnosis of dementia alone does not mean that this person can no longer execute documents or could not sign a power of attorney. But whether or not they understand what they're doing is what will determine whether or not they can actually do it. So, if we have an individual with a diagnosis of dementia, but they still understand what's going on. They understand who their family members are. They understand what they have. And they're still in a position where they can direct other people to do things on their behalf. And most importantly, they understand the weight of what appointing an agent will mean, what their actions will ultimately mean, then they're perfectly fine and could still execute a power of attorney, hopefully sooner rather than later. But if they have a diagnosis and they are confused, they no longer know their loved ones, they no longer understand what they have, they're not really in a position to direct others on how to manage their affairs, then a power of attorney may not be an option. At that point, guardianship through a court may be the only option left. So is dementia the end all be all as far as getting a power of attorney? Not necessarily, as long as the person has the requisite capacity. If they do not, however, it's a little bit too late.
Great. Thank you so much. Okay.
All right. Do I need an attorney for estate planning? Let's do that.
Okay, when you're ready.
This question is a little bit near and dear to my heart. Do I need an attorney for estate planning? Naturally, you may think I'm a little bit biased because I think you probably should have an attorney for estate planning. Do you absolutely need one? Not necessarily. You could certainly find a number of documents online, the legal Zooms of the world, even, somewhere like Office Depot. Whether or not you should actually take that chance in drafting those documents yourself is a whole nother story. It's important to understand that these are not just documents. They're documents that tell a court or other individuals how you want your estate to be administered after your death, what type of powers you want your agent to have, really what type of limitations you want placed on them in some cases. So not having the legal background to understand the type of words that you're using, not having the legal background to understand how things should be properly executed could end up hurting you even more than if you had nothing in place at all. Do you need an attorney? Probably not. Should you have one to make sure that things are done properly? Definitely so.
That was great. Thank you so much. Okay.
All right. So, what assets are included in an estate?
Great. I'll stop. And when you're ready.
Oftentimes, when we are assisting individuals with probate, it becomes clear that a lot of people don't really know what assets are actually included in a probate estate. The big one is that people will often tell me, well, this person received a large sum in life insurance proceeds, or they got all the 401k money. But those things are typically not part of a probate estate. The assets that are generally included would be real property, would be any personal property that the person had, clothing, personal items, furniture, cars, etc. But things like life insurance policies, they would have beneficiaries. So unless no beneficiary exists, it would not be a part of the probate estate. Things like a 401k, again, would have beneficiaries. So unless there are no valid beneficiaries listed, it would not be a part of a probate estate. And lastly, things that are in trust are in trust. They would not be part of that individual's estate. So anything that is real property that would not pass to someone automatically because it's not owned by more than one person, anything that does not have a beneficiary, or any personal property that a person owns, all of those would be part of a probate estate.
Great. Thank you so much. I think we can record one more than the April Fool's one, and we can see other topics. Is that okay?
Sure. I'm trying to think about how to structure this April Fool's one, because I feel like I did like a series of things.
Yeah, if you want me to, I can share the video on my screen after we record the last question, so you can have a better idea of the video. So I don't know if you can see my screen for the frequent questions.
Yes.
Okay.
Let's go to can an executor override a beneficiary?
Okay. Great. Thank you so much. I'll stop. And when you're ready.
A question that comes up in contested probate matters a lot is whether or not an executor can override a beneficiary. What I mean by that is, can the executor just go ahead and do whatever they want and administer the estate however they want without consulting a beneficiary? And the short answer to that is yes. The beneficiary's job, of course, is to receive from the estate, but the executor or personal representative's job is to protect the estate, to administer the estate, and to make sure that everyone gets what they're supposed to receive. So their job is not necessarily to protect the heir's feelings or to do what they're requesting or what they're wanting, but to make sure that they protect and take care of the estate, take care of the person's final expenses, locate any heirs, locate any assets that are out there, and do what is in the overall best interest of the estate. A lot of times heirs think that they can direct personal representatives or executors and tell them what they should and should not do because it's something that they're ultimately going to inherit. But the reality is that person is in charge. So they do get to decide how to administer the estate as long as they're doing that with the estate's best interest in mind and they're not doing anything to harm any of the heirs.
That was great. Thank you so much.
I'll do one more just because it's at the
Okay.
top of my mind right now. Should husbands and wives have I think separate wills or something like that?
Okay, let me go back to the file. Okay, this one, right? Can a husband change his wife's will?
No, I think it's should married couples.
Have separate wills?
Yeah, I think so. I think I saw something like that. Should married couples have separate
Yeah.
wills?
Okay. Great. I'll stop. And when you're ready.
Another question that comes up actually more often than I thought is whether or not married couples should have separate or joint wills. The answer to that is couples should absolutely have separate wills. Even though the two become one after you become married, your estates are separate. They're separate from one another. Even if you were to die at the same time, they would be probated separately. Even if your wishes are exactly the same and you want them to go to exactly the same people, having a joint will is a big no-no. So while you may be one, each of you require your own estate plan indicating who you want your assets to go to and who you want to ultimately administer your estate and serve as your agent during your lifetime.
Wow, that was interesting. Thank you so much. Do you want to record another one?
I think I'm good on that.
Okay.
Tell me again about the April Fools and how you would like that.
Video. Okay. I have it actually here. I will share again my screen just to show you the video. Okay. This is 3 years ago. That's this one. Okay. Oh my God. Did you see my screen?
I did not.
Oh my God, I played the whole video
Oh,
and I thought
goodness.
you were watching it.
No,
Oh my God, I'm so sorry.
that's okay.
Oh my God. Okay, let me do it again. I'm so sorry. Can you see my screen?
No, I can't. I think it's, oh, okay.
It's
It's
I'm
loading.
really sorry. Okay. So just to make sure, could you please confirm it when you see my
Yeah, I
screen?
see it.
Okay, great. I'll play the video.
Now, I know April Fool's only comes
Can you hear the video?
I can.
Okay, great.
once a
I'll play
year,
it.
but for our purposes, it is April Fool's month. This week, we're going to talk about DIY estate plans and why they're not such a great idea. You could buy some software, you could buy forms from Office Depot, you could
Mhm.
download a template, or you could pay for an online service such as LegalZoom to create your own estate plan. But they may or may not actually address all of your needs. Why? Because they can't really account for every single person's family dynamics. They can't even necessarily account for all the nuances in state laws. So, the best thing to do is to actually meet with a professional who can help you craft an estate plan, not just create a random document.
Okay. So
Okay, so are you
double
wanting
check.
something similar or are you wanting me to talk about
If you can create something similar, I think that would be cool. I don't know if there's something that has changed in these last 3 years related to uh, DIYing your estate plan that you would like to add, or if you want to like kind of recreate this video.
I'm trying to think. Maybe I could do the three.
Because what we can do is just like something similar to this video, just to introduce April Fool's month. And next week we can record more April Fool's video to
Okay.
share them during the whole month. Okay. So I'll mute myself, and when you're ready.
Hello, hello, hello. All right. So throughout the month of April, we are going to be highlighting some of the most foolish estate planning mistakes. So stay tuned and we'll bring you more. I don't know if I like that.
Okay. Do you want to to record it again? Estate planning mistakes. I love that theme. Um. Okay. Maybe you can. I actually like that intro. And you can complement it with, and the first one or something like that is to create your own estate plan without, I don't know, some guidance or asking a professional, something like that. I don't know if you like that idea.
Hmm. Okay, I think I have one.
Okay, great. I'll mute myself.
Hello, hello, hello. Throughout the month of April, we are going to be highlighting some of the most foolish estate planning mistakes. Next week, we will talk about why you should not have 50,000, okay, maybe not quite 50,000, but why you may not want to have multiple powers of attorneys, all of them having to agree to make a decision. Foolish estate planning mistakes throughout the month of April. Stay tuned.
That was amazing. Thank you so much. Okay, great. Okay, we have 10 minutes left. I think we can record that video next week. That's okay with you?
Yeah, that's fine. Or since, well, yeah, that's fine because I know you have, what, 16 short ones now?
Yeah, don't worry about it. Okay,
Okay.
or do you think it's like a short, it can be a short video, or you're gonna take like, I don't know, maybe 5 minutes or more?
I don't think it's going to take 5 minutes or more.
Okay, so do you want to record it now?
We can.
Okay, great. Then I'll mute myself and you can go for it.
All right. Foolish mistake number 1, appointing a whole bunch of people to serve as your agent. Lots of clients, specifically the ones who have lots of children, want to make all of them involved. So in some cases, they will say to me, hey, I have 3 children. I want all of them to be my power of attorney. I want all of them to agree. I want all of them to do everything jointly because I know together they make better decisions. That sounds good in theory, but it actually makes it more difficult for your agent. Can you imagine having to have 3 people agree to do every single thing? Can you imagine having to have 3 people present just to do banking transactions? What if one of them does not agree? Does that really help you or does it hinder you? So while it may sound good to have all of your people involved in your plan and make all of them responsible and force all of them to agree to make decisions for you, and while they may truly be better together, when they're trying to serve as your agent and they're having to consult with 2 other people, it makes it super difficult to deal with banks, super difficult to make decisions, and it may actually delay decision making on your behalf. So that would actually be considered a foolish decision. The best thing to do is to appoint one person to be in charge. That way, they're not having to consult with a whole bunch of other people, and things will be a lot smoother. Don't make that foolish mistake. Do not appoint multiple people to serve as your agent.
That was amazing. Thank you so much. Okay, I think that's it for the videos that I wanted. I don't know if you want to record something else at the moment, or we can wait until further
No,
meetings.
we can wait and record some more
Okay.
next week.
Great. Then I'll finish the live session.